Hello everyone, my name is Aman and in this video we are going to learn about directive principles of state policy covered under part 4 of Indian Constitution and ranging from article 36 to 51. So why did I choose this topic? The reason being simple, that we often understand the importance of fundamental rights और फंडामेंटल ड्यूटीज, बट हम डीपीएसपी को जो इम्पोर्टेंस मिलनी चाहिए उसे अंडरस्टैंड नहीं कर पाते हैं. These are non-justiciable principle. What does it mean? I'll tell you in further slides. But the importance that they have, it is often misunderstood, and for the very same reason I have chosen this topic, number one. And number two, this golden trinity or golden trio of fundamental rights, DPSPs and fundamental duties, it is under part 3 of the Indian Constitution, part 4 of Indian Constitution and part 4A of Indian Constitution. These three parts reinforces the Thomas Hobbes idea of social contract. How? ये हम आगे जानेंगे. तो ये मेन रीजन है जिसकी वजह से मैंने ये टॉपिक ऐसे रैंडमली पिक किया है. Although we are going to cover the Indian polity and constitution in detail in our further lectures. Okay, so let's start the topic. Okay, so as I said, DPSPs are there in the part 4 of Indian Constitution, ranging from article 36 to 51. Okay, at this stage मैं इतना मान के चला हूँ कि आपको पता है कि पार्ट 4 और पार्ट क्या होता है एंड व्हाट आर आर्टिकल्स. ओके, अगर मुझे सिंपली पुट करना पड़े तो there are 25 parts in Indian Constitution, 25 parts. Each part is like a chapter. Like part 1 contains information about union and its territories, part 2 about citizenship, part 3 about fundamental rights. So each part is like chapter, and part 4 is the chapter regarding some principles, some directives to the government. What are the directives? वो हम आगे further इस लेक्चर में पढ़ेंगे. And what are articles? Articles are nothing but provisions or information in that particular part. Okay, for example, article 12 to 35 is part 3, which has information about our fundamental rights. So article 12 talks about state, that who is being limited to arbitrarily use the power on citizen. आपके fundamental rights किससे बचाए जा रहे हैं? State से. So what is state? This is given in the article 12. So long story short, article is the provision contained in any part of the constitution. Okay, so till now we know what is part. Part is nothing but a chapter of the constitution, और जो content होता है part के अंदर, that is being written under articles. And this article term is specifically for the constitution only. If there is any code or there is any other law book, वहाँ पे use किए जाते हैं provisions को, वहाँ पे section term से replace किया जाता है. Okay, so this section term is for any other law of the land. For example, Hindu Code Bill. For example, any CRPC, IRPC, CRPC or IPC now replaced with भारतीय न्याय संहिता and all. Okay, so अगर मैं बात करूं तो we know what is article, what is part, and we also know that we are going to cover the part 4 of Indian Constitution because it is an unsung hero of the constitution and it has some directives to the government that what should government do. Okay, so अगर मैं थोड़ा सा आपको context देने की कोशिश करूं, part 3 is fundamental rights, as I have already said. Part 3, third part of Indian Constitution, third part, it restricts the government, that government should not do this, government should not do this, government should not discriminate on the basis of religion, race, caste, place of birth, government should not abridge a fundamental right of a person, or government should treat equally before law, or government should not snatch a person's life and personal liberty. So it is of a negative connotation, which limits the state, from arbitrarily using the power to install or instill rule of the law. Okay, rule of law. And part 4 of Indian Constitution has positive connotation or positive obligation on the state. These are totally opposite positive obligations. Like government should do this, government should intervene to prevent the concentration of the wealth in the society, to make laws or provision for the equal pay and equal work. Okay, so these should be read together as said by Supreme Court in Minerva Mill case, that these are the two wheels of a chariot of the Constitution, and principle of harmonious construction was given, which we will be reading in further slides. Okay, so now DPSPs are contained in the part 4. They are the guiding lines to the government for making any laws, programs, policy, bylaws or any mission. Okay, इतना हमको पता लग गया है. And they are being borrowed from Irish Constitution, and Irish Constitution had borrowed this idea from the Spanish Constitution. ठीक है, तो हमने अगर एग्जाम में क्वेश्चन आता है तो we will be answering Irish Constitution. Irish Constitution ने कहाँ से लिया है? Spanish Constitution से. ठीक है, let's move further. Okay, directive principles are also inspired from instrument of instructions. What is instrument of instructions? It is a written direction issued to the Governor General or governors at the time of colonial India. These directions were issued by the British Crown or British Parliament to the Governor General that you should do this, you should do that to rule in India. और उसी lines पे now Constitution is saying to the ruling government or state. What is state? We will be knowing in further slides. Okay, कि government is Constitution is directing the government or the state. Okay, state contain all three organs: legislature, executive and judiciary. Some written direction are there that you should intervene. For what? To achieve the idea of welfare state. Welfare state. Now what is welfare state? What is police state? This difference is very important to know. Okay, so अभी तक हमको क्या पता लगा है कि हम पार्ट 4 ऑफ द इंडियन कॉन्स्टिट्यूशन पढ़ रहे हैं. आर्टिकल 36 to 51 इसमें इंक्लूडेड है. नंबर 3, ये इंस्ट्रूमेंट ऑफ इंस्ट्रक्शन जो कि गवर्नमेंट ऑफ इंडिया एक्ट 1935 से इंस्पायर्ड है. इट इज़ टेकन फ्रॉम द आयरिश कॉन्स्टिट्यूशन, और आयरिश कॉन्स्टिट्यूशन ने इसे स्पेनिश कॉन्स्टिट्यूशन से बोरो किया था. एंड दे आर नॉट एनफोर्सेबल इन द कोर्ट्स, ये मैं आगे आपको बताऊंगा. एंड दीज हैव पॉजिटिव कॉनोटेशन. ये जो इंस्ट्रक्शन है कॉन्स्टिट्यूशन की गवर्नमेंट के लिए, ये डिमांड करती है गवर्नमेंट से कि आप आइए इंटरवीन कीजिए ताकि एक वेलफेयर स्टेट की एस्टैब्लिशमेंट की जा सके. व्हाट इज वेलफेयर स्टेट, इसे मैं बता देता हूँ. सो ट्राई टू रिकॉल बाय योरसेल्फ कि व्हाट इज वेलफेयर स्टेट एंड व्हाट इज पुलिस स्टेट. वेलफेयर स्टेट इज very simple to understand, that any state which acts as a safety net to marginalized section, to downtrodden section, to the section which is at the bottom of the economic strata, that is known as welfare state. It acts as a safety net. For example, what government actually do? There are two sections of the society, mota moti, haves and have nots. Haves यानी रिच क्लास, एंड हैव नॉट्स. Okay, they are rich, they have all the material resources and factor of production, I would say, and they are poor. they do not have enough resources, financial resources or factor of the production, and they are marginalized at the bottom of the social and economic strata, है ना? तो गवर्नमेंट what government actually do, government intervene, take taxes, progressive taxation, okay, as income rises tax slab also rises, and redistribute in the form of policies and programs. For example, PM Kisan, है ना, 6,000 rupees annual installment to the certain category of farmers. For example, National Food Security Act. For example, MG Narega. For example, Ayushman Bharat. These are some of the schemes or example of the redistribution of resources from haves to have-nots. And long story short, we were reading about what is welfare state. Welfare state is where government acts as a safety net to redistribute the resources from richer class to the poorer class to establish a emancipated society. ठीक है? और इसी वेलफेयर स्टेट, इस इंटरवेंशन के लिए ही डीपीएसपीस को रखा गया है. इट मीन्स कॉन्स्टिट्यूशन फोर्सेस द गवर्नमेंट टू इंटरवीन. ओके, कॉन्स्टिट्यूशन forces the government to intervene. So it is a positive obligation. Okay, next, now comes the actual content of the part 4. So article 36, definition of state, है ना? 36 reads like, the definition of state. ये जो भी प्रिंसिपल्स है, जो भी डायरेक्शंस है, डायरेक्टिव मीन डायरेक्शंस बेस्ड ऑन सर्टेन प्रिंसिपल्स. आई एम सॉरी इफ देयर इज नॉइस इन बैकग्राउंड. ये किस पे लागू होते हैं? स्टेट पे. व्हाट इज स्टेट? स्टेट इज लेजिस्लेचर एट यूनियन लेवल, एग्जीक्यूटिव एट यूनियन लेवल, जुडिशरी only while performing administrative function, not as judicial function. This is very important and it can be asked in exam, that the term state mentioned under article 36 of Indian Constitution, does it include judiciary? Yes, it does. What? While performing only judicial function. I'm sorry, administrative function, not judicial function. And now let's move to the, okay, it is article 12, because article 36 says that the definition of the state in this part is same as the definition under article 12, because it is the first article of the fundamental right and it is the first article of directive principles. So state have the same meaning, and state is not just union government or state government or local government. It has wider connotation. For example, okay, I hope this is visible. The term state in this part shall include, ये बहुत साउंड आ रही है यार, गवर्नमेंट और पार्लियामेंट ऑफ इंडिया, स्टेट लेजिस्लेचर, लोकल अथॉरिटीज, अदर अथॉरिटीज which will include PSUs, bodies, universities, government universities, and even companies, government companies. And judiciary, while performing the judicial function, as I said, is not considered as state, but while performing administrative function, for example, appointments, recruitment or service matter, will be considered as state under article 36. Some case laws बहुत सारे हैं, हमको सभी याद रखने की ज़रूरत नहीं है, लेकिन एक दो हम याद कर सकते हैं. फॉर एग्जाम्पल, जी टेलीफिल्म्स लिमिटेड वर्सेस यूनियन ऑफ इंडिया 2005. In this landmark judgment, court held that BCCI, which is registered as, I think, as a trust under Tamil Nadu Cooperative Societies Act, is not considered as state under Article 12. Is not considered as state. And one is Chandra Mohan Khanna versus NCRT case. इसमें जुडिशरी ने ये कहा था कि NCRT is not a state under Article 12. So मेनली हमको ये पता होना चाहिए कि स्टेट इज नॉट जस्ट यूनियन गवर्नमेंट और स्टेट गवर्नमेंट और लोकल गवर्नमेंट. इट हैज़ वाइडर कॉनोटेशन. इवन universities, government or government companies, and like yes, there is a principle called principle of instrumentality or agency test. It is given by Justice P.N. Bhagwati. It said if any body is instrumental government body or agency of government, that will be considered as state. Okay, so let's move to the next topic. Okay, application of the principles contained in this part. The provision contained in this part shall not be enforceable in any court of law. This is the major criticism of directive principle of state policy, that these cannot be questioned in any court of the land, or these are non-justiciable. It means you cannot go to the court to enforce your Dpsp. You can go to the Supreme Court or High Court for the enforcement of your fundamental right if violated, but you cannot do so with Dpsps. Why? Why they were not justiciable? The answer being simple, कि जब देश आज़ाद हो रहा था, when the constitution were made in 1950, we did not have enough resources to implement all Dpsps. Dpsp says that there should be Panchayati Raj institution which will act as a unit of self-government in all villages. But we did not have enough resources. India was facing extreme poverty, abject poverty at that time. We did not have enough cereal grains to eat. We were importing cereal grains under PL 480 program from United States. PL 480. We did not have any industry set up because of the drain of wealth by colonial government for 200 to 300 years. So at that time there were resource crunch. This is the main reason. Second, we needed time at that point of time. टाइम की बहुत ज़रूरत थी, हमारे पास इनफ टाइम नहीं था. फॉर एग्जाम्पल, इफ़ यू वॉन्ट टू इम्प्लीमेंट schemes like Ayushman Bharat, it needed time. You could not achieve universal health for India in just few months. It takes years for a vast country like India. So time की बहुत ज़्यादा ज़रूरत थी. And social acceptance. For example, in a diverse country like India, social acceptance is also main reason. Like UCC, Uniform Civil Code, is not implemented even now. सिर्फ उत्तराखंड और गोवा में पोर्चुगीज के कारण ही implemented है. बाकी social acceptance is not there because of the diversity. So these were the main reason that government was fighting many battle at the same time at the time of independence. So उस समय पे DPSPs को justiciable बनाना will overburden the government. That's why these were made non-justiciable. These are the moral obligation on the government or political accountability tool. ठीक है? If they are not, as said by Dr. Ambedkar ji, if they are not justiciable in the court of law, they are justiciable in the court of public. Okay? Because if they are not implemented, the government of the day can be voted out by the people. Okay? So Article 36 says about state on whom these positive obligation will apply, and Article 37 says the enforceability of DPSPs, that they are not justiciable, they are not legally binded on the government, and they cannot be enforced in any court of law. So, but they do have significance because of their moral obligation of the government, their political accountability, and they are justiciable in the court of people, not in the court of law. Okay, let's move to the next slide. Okay, so this is the debate behind justiciability and non-justiciability. Sir V.N. Rao has strongly advocated for making two categories of DPSPs, one by and which will be the enforceable in the court of law, and second which will not be. But ultimately the Constituent Assembly decided to put all the DPSPs in the non-enforceable category. Okay, और सप्रू कमेटी भी इससे संबंधित है, जिसने कहा था कि DPSP जस्टिसिएबल भी हो सकते हैं, नॉन जस्टिसिएबल भी हो सकते हैं, इंडिविजुअल राइट जस्टिसिएबल भी हो सकते हैं, नॉन जस्टिसिएबल भी हो सकते हैं. हमें ऐसे बाइफर्केशन करनी चाहिए, और जहाँ से कहीं ना कहीं DPSPs का आइडिया आता है, क्योंकि जस्टिसिएबल तो फंडामेंटल राइट है ही, एंड नॉन जस्टिसिएबल आर DPSPs. Okay, Article 38. Article 38 says state to secure a social order for the promotion of the welfare of the people. It just amplifies the preamble. जो भी preamble में wording है, that India is be the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, ये उसी आइडिया को एम्पलीफाई करता है आर्टिकल 38, that state to secure a social order to promote the welfare of the people. Okay, so it talks about minimizing the inequalities or in income, and to eliminate, like you cannot eliminate inequalities in income, so it is said that they should be minimized only, but you can eliminate the inequalities in status. So minimize the inequality in income and eliminate inequalities in status, facilities and opportunities. Okay, this is the exact wording of Article 38 of the Constitution. And welfare state and police state, I have already told you. Police state is the state where there is a dictatorship. Colonial India is the prime example of police state. North Korea is the prime example of police state, where only focus is on maintaining law and order, and police state can curtail the freedoms of individual, and it is the idea of being opposite of the welfareism. Okay, for example North Korea हो गया आज का, and colonial India हो गया, and other dictatorial regimes that we know. And example of this article being implemented is National Social Assistance Program, Pradhan Mantri Kaushal Vikas Yojana, PM Kisan, and Smile Scheme. You can also write many schemes for your active revision. Smile Scheme is for transgender and beggars, है ना, to make them Atmanirbhar or for their entrepreneurships. Okay, so this was the idea behind Article 38 of Indian Constitution, that it will amplify the preamble. Next article, Article 39. 39 has 6 provisions under it. Number 1 says that state should strive that the citizen, men and women, equally have right to adequate means of livelihood. Adequate means of livelihood. MG Narega is the prime example of it. MG Narega or BVG Ramji is the prime example of this fact. Number 2, that the ownership and control of the material resources of the community should be so distributed that it should serve the common good. It is very, very important. Article 39B and 39C. These are very, very important articles because they directly confront the fundamental right. And there are special provision in fundamental right under Article 31C regarding these two provisions, that if some of the DPSPs, for example Article 39B and 39C, violates fundamental rights, mainly Article 40, 19 and 31, then they should not be declared void by judiciary. So these two provisions have more power than some of the fundamental rights like 40, 19 and 31 of the Indian Constitution. And this was upheld by the Supreme Court in Keshwananda Bharati case, as they said, or Honorable Supreme Court said, that they do not disturb the basic structure of the Indian Constitution. What is basic structure? We will know. So, if I have to boil it down for you, that 39B and 39C are more powerful than some of the fundamental rights under Articles 14, 19, and 31. Upheld in Keshwananda Bharti case and reiterated in Minerva Mill case of 1980 by Honorable Supreme Court. What does they say? That ownership and control of the material resources should be so distributed that they should serve the best interest of the common good. Number one. Number two, the operation of the economic system should not result in the concentration of the wealth and means of production to the common detriment. So this is a direction to the government that prevent the concentration of the wealth. Okay, and this is also direction to the government that distribute the material resources. Prime examples of these two laws are these two provisions are Land Reforms Act. जितने भी लैंड रिफॉर्म्स हुए इंडिया में, एवोल्यूशन ऑफ जमींदारी, लैंड सीलिंग, टेनेंसी एक्ट्स, those are because of these two DPSPs. Okay. Number fourth provision is there should be equal pay for equal work. Equal pay for equal work for both men and women. And Parliament has enacted Equal Remuneration Act of 1976 for the same. So this was also a obligation on state which has been fulfilled. And the fifth provision is the health and strength of the workers of men and women and the tender age of children are not abused. Workers and children are not abused, and that citizens are not forced by the economic necessity to enter in a vocation that is unsuited for their age and strength. For this very same reason, we have enacted labor codes, Factories Act, Industrial Dispute Act, labor codes of 2019 and 2020, like code on wages, code on social safety, occupational safety and hazard, and industrial relations. Okay, and the last but not the least, this was added through 44th Amendment of 1978. 44th Constitutional Amendment of 1978, a special provision for children, that the children should be given opportunities and facility to develop in a healthy manner and in condition of freedom and dignity, that the childhood and youth are protected against the exploitation and against moral and material abandonment. Okay, so to protect children's dignity, to protect their opportunities and facilities, to protect them against exploitation, this provision was added by 44th Constitutional Amendment Act of 1978. Okay, so Himachal Pradesh Tenancy and Land Reform Act of 1972, this has been directly inspired from these two principles. 39B, material resources should be distributed so that it should serve as a common good, or 39C, that the operation of economic systems should be such that it should prevent the concentration of wealth for common detriment. Okay, and yes, and Prevention of the Child Labor Act was enacted in 1986 and amended in 2016, and Beti Bachao Beti Padhao program, these are in the alignment of this provision. Let's move to the next part. Okay, equal justice and free legal aid. The state shall secure that the operation of the legal system promotes equal justice on the basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes. For the very same reason, matlab poor people do not have financial resources to get justice in India. Financial resources to get justice, because it takes very much amount to get justice in India. For the very same reason, if you are government will provide you a government lawyer. Government will provide you free legal aid if you are fighting against injustice. This is the article. Okay, so this is Article 39 capital A. Capital A means this was inserted by an constitutional amendment act. Generally, capital A means this. This is not a clause, okay? This is Article 39A. There is a difference. 39A, this is Article 39 clause A, and this is Article 39A. This is a complete article in itself. This is Article 39 but having clause A in it, okay? So Article 39A was added through 42nd Constitutional Amendment Act, which provided for the free legal aid, and for the very same reason, government has enacted National Legal Service Authority Act of 1987 for the constitution of Lok Adalat. We will read it in further classes, and Salsa at state level, okay? Supreme Court has also made some of the committees like National Legal Service Committee, whose patron-in-chief is CJI. This was added, this provision was added through 42nd Amendment Act of 1976. So the constitution is directing the government that the people should get social, economic or political justice, and for the very same reason they should have access to financial or legal sources, and it is your duty, government, to provide the same, to provide them the same. And that's why this act, this provision is there in the constitution, okay? And the last but not the least for today's class, organization of the village panchayat. The state shall take steps to organize village panchayats and endow them with such powers that as may be necessary to enable them to function as a unit of self-government. This is Gandhiji's idea of Gram Swaraj. This is Gandhiji's idea of rural self-government or urban local bodies, okay, or village republics. So Gandhiji's wanted democracy at grassroots level, democratic decentralization, and for the very same reason, government came with 73rd and 74th Constitutional Amendment Act in 1992 and 93, and it is one of the key landmark Gandhian principle in Dpsp, and it is under Article 40 of the Indian Constitution. We will read further articles in our upcoming classes from Article 41 to 51, and we will also see the constitutional debate behind these principles. But I think this is enough for today's lecture. But we will do some PYQs, and we will also do some mains analysis. How can we use mains question? For example, I have told you about Article 39 clause F about children, that they should not be discriminated against, they should be given enough opportunity, they should be given dignity and freedom. You can directly use it in the social justice topic if question is on children, which was asked in Hpas 2025. Okay, so you can use any of the provision of these DPSPs in your mains answer writing. You can use it, them in polity and constitution, in governance, in IR, because Article 51 talks about it. We'll read it. You can use it in ethics paper GS4, and you can also use them in society and social justice part. Okay, so now let's do some PYQs. We'll read these in further classes from Article 41 to 51. Okay, we have read this. In India, Legal Service Authority provide free legal service to which of the following types of the citizen? All citizen? No, not all. Only poor citizen. There should be a limit, not all. Because if all citizens are being given free legal aid, then what is the point of giving that legal aid? So all नहीं हो सकता, इसलिए 4 is wrong. So now answer should be between A and C. Person with an annual income of less than 1 lakh, maybe Okay, if you have read this, you can take it or cross it. But if you don't know, second statement पढ़ते हैं. Transgender with an annual income of less than 2 lakh, sorry. And third is member of the other backward caste or OBC with an annual income of less than 3 lakhs. 3 lakhs is not a criteria for OBC. We have, if I have to guess it smartly, that they have creamy layer criteria of 8 lakh and 3 lakh criteria I have never read about other backward caste. So this might be wrong, and this is wrong actually. So the correct answer is 1 and 2. For transgender it is 2 lakh, and any person with an annual income of less than 1 lakh, you will get free legal aid under Article 39 capital A of Indian Constitution. I'm sorry, there is a noise. Okay, provision in the Constitution of India, separation of the judiciary from executive in the public services. This is under Article 50 of the Indian Constitution, and yes, it is in the directive principle of state policy, UPSC question 2025. Valuing and preservation of the rich heritage of our composite culture, the fundamental duties. Yes, it is also correct. When we'll read fundamental duties, we'll read about it. And the third, prohibition of the employment of children below age 14 years. This is covered under fundamental rights. All three are correct. We have not read about the fundamental right and fundamental duties till now, but we'll cover it. Okay. Next question is, under the Indian Constitution, concentration of wealth violates concentration of wealth. Article 39, material resources, and 39C was concentration. Okay, so it violates directive principle. Which part of the Indian Constitution declares that the ideal of the welfare state? Obviously, directive principles of the state policy. We have read about it. Next question. With reference to the provision contained in the Part 4 of the Indian Constitution, which of the following statements are correct? They shall be enforceable in the court of law. They shall not be enforceable in the court of law. We have done a detailed discussion on this. इन दो में से वैसे भी कोई एक ही स्टेटमेंट ठीक होगी, because they are completely opposite to each other, and we know that first is not correct and second is correct. So first is not correct, and second is correct. I'm reading the third statement. The principle laid down in this part are to influence the making of policy and programs of the state, and this is absolutely correct. Answer is 2 and 3. Easy peasy. Other than the fundamental right, which of the following parts of the Indian Constitution of India reflects the principles and provision of the Universal Declaration of Human Rights? This is an easy question. Why? Because you have to amplify these types of questions. Think broad. It is an open-ended question. So the answer should be all of the above. क्योंकि अगर थोड़ा सा भी influence कर दिया Universal Declaration of Human Rights को, दो statement ठीक हो जाएगी. So you cannot negate, because preamble do contain the idea of justice, liberty, equality, fraternity. It contains the idea of welfare state, and fundamental duties also include the idea of welfareism. So you cannot disprove or discard in such open-ended question. So go with all of the above, because these are very light statement and these are very open-ended. Next question, which principle among the following was added by the 42nd in the directive principles? 42nd, equal pay for equal work, it was already there. Participation of the workers in the management of industry, this is under Article 43A. We will read about it. And because 43A capital A, so it was inserted through 42nd only. It is the answer. Okay, we will read about it. Okay, securing living wage and right to work, this is Article 41, living wage Article 43. We will read about it. Consider the following statement. With reference to the Constitution of India, the directive principle of state policy constitute limitation on. These do not limit government. Government is limited in fundamental right, not in Dpsps. Okay, so this enable this direct positive obligation or positive direction, not limitation. So not legislature, not executive. Answer is neither one, not, because Dpsps never limits the government. You can make thousands of laws to fulfill the demand of even single Dpsp. The ideal of welfare state of Indian Constitution is enshrined in easy. Welfare means directive principle of state policy. And consider the following statement regarding the Dpsps. The principles spell out the socio-economic democracy. These are fundamental in the governance of the country and spells out Socio-economic democracy. This is covered under the article of 38 or 37. I'm sorry, 37. The provision contained in these principles are not enforceable by any court. This is correct. This is also correct. Socio-economic democracy by Dpsps, and political democracy by fundamental rights. Okay, and it is also said that these are fundamental in the governance of country. So you can also use them in your governance answer. Fundamental in the governance. So answer is both 1 and 2. Next. In the Constitution of India, the promotion of international peace and security is included in Dpsp under Article 51. Under Article 51. According to the Constitution of India, which of the following are the fundamental in the governance of country? I just told you that these are directive principles. खत्म ही नहीं हो रहे हैं तो consider the following provision under the directive principle of state policy as enshrined in the Indian Constitution. Securing for citizens of uniform civil code. क्या? Yes, under Article 44. Organizing village panchayat. 40. Promoting cottage industries. 43. We will read about it. We will read about this also. Securing for all the workers reasonable leisure and cultural opportunities. This is also under Article 43 only. So हमको क्या बताना है? Gandhian principle. Gandhian principle cannot be uniform civil code. Okay, it is a liberal intellectual principle. What is this classification? I'll tell you that Dpsps are divided into 3 categories. One is socialist, one is Gandhian, and one is liberal intellectual. We'll read about it. So uniform civil code comes under liberal intellectual. So I'll cut first statement and I'll get the answer 2 and 3. Securing for all the workers reasonable leisure and cultural opportunities. This is under socialist principle. Okay, statement number 4. So option B is the correct fit. Next, with reference to the Constitution of India, consider the following statement: fundamental right, fundamental duty, directive principle, state policy. Which of the provision of the Constitution of India are filled by the National Social Assistance Program? Not fundamental duty or fundamental right. It is the social assistance. So it is only Dpsp. Okay. The purpose of the inclusion of the directive principle of state policy in Indian Constitution is to establish social and economic democracy. Okay, not social, only social, but also economic democracy. Economic, we have already read about 39B and 39C. We will read about it, why this social word is here. And Gandhian democracy is not there. Though Gandhian ideals are there, but not Gandhian democracy. And for political democracy, we have fundamental rights. Okay, so the comprehensive answer is social and economic democracy. Okay, so this is the conflict of the DPSP with fundamental rights. ये बहुत बड़ी कॉन्स्टिट्यूशनल डिबेट है और इसे हम आने वाले फर्दर लेक्चर्स में कवर करेंगे. आज के लिए बस इतना ही. आई होप आपको लेक्चर पसंद आया होगा. एंड आज हमने थोड़ा बेसिक कवर किया एंड विल टेक इट टू द एडवांस लेवल एंड we will also see some of the main answer that can be written by using this content. And thank you for watching this video. Okay, and try these questions. Let me give you, try these questions. These we have already read these things. Okay, these question. National Commission for Protection of the Child Right has to address the challenge faced by the children in the digital era. Examine the existing policy and suggest the measure for the same. है ना? ये HS 2025 का क्वेश्चन है. इससे DPSP की मदद से इसका इंट्रो या कंक्लूजन लिखने की कोशिश कीजिएगा. एंड दिस इज डायरेक्ट क्वेश्चन ऑन DPSP. ट्राई टू आंसर इट ऑल्सो. ओके, सो थैंक यू फॉर वॉचिंग दिस वीडियो. And if you like this video, please visit our application on this QR code, and all the links are also given in the description box. Thank you so much, and I'll see you in the next one.